whenever an offense is committed, it is the duty of the police to actually register the FIR and then investigate the matter in the proper and just manner. The purpose of the investigation generally is to ascertain whether the offense has been committed. At the same time, the person who have committed the offense should be brought to justice. So during the investigation process, the police is duty bound to actually collect the evidence against the persons who have committed the offense. And in some cases, and the appropriate cases, I would say, the police is supposed to arrest the accused also. So they should not be in a position to either threaten the witnesses or tamper with the evidence, or if there are chances that they would flee, they would run away, then in those kind of situations, the police can also arrest the accused persons. But we have seen so many cases. In all those cases, you might have read in the newspaper also, and if you go by the central government's data related to the crime which have been committed by the police itself, whether it is related to police brutality or related to the corruption which is in the police department, there is general perception among the public at large, and public believe that the police is corrupt. And there is, to some extent, not to some extent, but to great extent, I would say, there is truth behind this notion, this perception which is in the public itself. And for this, the police itself is responsible, because there are so many cases of corruption against the police also. There have been cases, and since the advent of the CrPC in 1973, the police actually tries to save the accused in many cases. They take money, they get influenced by the political pressure or some other kind of pressure from the department also. The investigating officer actually defies his duty, and if there are more than one people who have committed the offense, the police will try to actually take the name of some of the accused out of the case. So public believe that in those kind of situations, अगर police ऐसा करेगी तो what can they do? And I would say that the courts are actually not bound, that the hands of the court are not tied. For the basic reason, when the CrPC was drafted, it was redrafted in 1973, implemented in 1973, and the government had the idea that there would be cases wherein the police might try to save the people who have committed the offense. यानी जिसने गलती की है, जिसने क्राइम किया है, उसको बचाने की कोशिश कर सकती है पुलिस. For that purpose, the courts, which are the independent judicial system in our country, as per the constitution, the judiciary must be independent of any influence, threat, or any kind of influence which may come from the bureaucratic or legislative cycles. So at that point of time, there was one section which was drafted in CrPC, that was section 319, that is CrPC itself, which says that at any point of time during the inquiry or the trial, court, on the basis of the evidence which has been adduced before it, thinks that there is some other person who is involved in the case which has not been either named in the FIR or has not been charge sheeted by the police, or which the identity of that person has been concealed by the police, then the court can pass appropriate directions and summon that additional accused in the trial. Now recently in 2022 itself, in December, 2-3 days back actually, the Supreme Court has passed certain guidelines related to the power of the court under section 319. It is in the case of Sukhpal Singh Khaira versus State of Punjab. You can download the judgment in the in the description box, and I would say that you should read this judgment. It is a very good step which has been taken by the Honorable Supreme Court. Now, in the situations when the police tries to save the actual culprit who has committed the offense, so in order to save the actual accused, what police does is either does not include the name of the person in the FIR, or does not investigate against that accused. He is not named in the investigation process itself. If one of the witnesses tries to name that accused in his 161 statements, then the police might threaten that witness also. So after that, the charge sheet is filed, and generally charge sheet is filed against the people who have committed the offense. The charge sheet is filed through the senior police officers. It comes to the court, and as soon as the charge sheet is filed, the inquiry stage before the criminal court starts. During that inquiry period itself, after going through the entire documents, if the court believes that there is somebody else who has to be named in the FIR or who has to be charge sheeted or against whom the trial should proceed, then the court can pass a direction at that stage, And if after the charges have been framed, one of the witnesses comes before the criminal court, and in the witness box the witness says that, look, my lords, there were ABC who have been charged sheeted, but there was three more people, D, E, F, who have also been involved in the commission of the offense, and the police has deliberately tried to save them. So at that point of time, the court can exercise the power under section 319. Now, if you think that the court is overburdened and the court does not have time to actually go through the entire record, then the victim or the prosecution, they can file an application under section 319. The Supreme Court's case, which has come up recently in 2022, has clarified this situation and has said as soon as the application of 319 CrPC has to be filed before the trial court, it is the duty of the trial court to actually stop the trial at this stage, first decide that application and decide whether the additional accused has to be summoned or whether the application should be dismissed. In case the court finds it appropriate that the additional accused has to be summoned and there is some substance in that 319 application, at that point of time the court can summon that additional accused, and till this summoned accused, the additional accused, comes before the court, the trial of the other accused should not proceed. And if after summoning of that accused, the court finds that there can be a separate trial or there can be a joint trial, that has to be seen in the case-to-case basis. But this is a good judgment, because in many cases the victim feels that the person who has committed all the atrocities and who is the actual culprit who has to be brought to justice, and the police in collusion with that accused is trying to save that person, might be because of the influence of the money or influence of the power, then I would suggest that moving an application under section 319 would be the most appropriate step for the victim, because the courts are the independent body in India. They are not generally influenced by any political pressure, legislative pressure, or the pressure from the bureaucratic circles, and the orders passed by the court has to prevail in any situation and every situation. I would suggest that you go through this judgment so that you could understand the power of the criminal court, and especially in the cases when the police is trying to save the actual culprits